If you're in a domestically violent situation, there are processes in the legal system to help you. You can get a protective order, which will help you keep your abuser away from you, have custody of your children. It can vacate abuser from your house and keep abuser away from your school or your work. It seems like an overwhelming process to try to get a protective order, but it's actually easier than you may think. Let us help you walk you through it. So there are protective orders and peace orders. They're both what we fall on the umbrella of restraining orders, right? So protective orders are for people who are married to their abusers, if they're related by marriage or by blood, if you have a sexual relationship with your abuser, if you have children in common with your abuser, all those sort of relationship umbrellas, anything that were generally where you have a relationship with your abuser in any way or have had a relationship with your abuser in the past year. Anything other than that, like neighbors, a person at your workplace, maybe someone that your kid goes to school with, those kinds of things are filed under peace orders. If you are eligible for a protective order, you have to get a protective order. If you're not eligible for a protective order, then you would get a peace order. Now, protective orders are issued from a certain set of facts. You have to have grounds to get a protective order. In order to establish grounds for a protective order, you have to prove that there was an assault, there was an act that puts you in fear of imminent serious bodily harm. There can be rape or sexual assault, or attempted rape or sexual assault. Stalking is also one, false imprisonment, or mental injury of a child. Those are the grounds for protective orders. Unfortunately, under the law currently, harassment is not a ground for a protective order. It is, however, a ground for a peace order. Now, in order to get a protective order, you go to the district court or the circuit court during working hours. If you need a protective order and it's not during working hours, you would go to the court commissioner in your county. Here in Montgomery County, the court commissioner is in the district court building. It's on North Jefferson in Rockville. There are a side door on the left side of the courthouse where it says commissioner. You go in that door. That's after hours, on weekends, or on holidays. When you go to the commissioner is going to ask you to fill out what's called a petition for protection for domestic violence. You'll fill it out. You'll tell the court what happened, what your relationship to the abuser is, and what happened to cause you to come seek a protective order. The commissioner will likely grant you an interim order. And I say it's likely because the burden of proof to get interim order is relatively low. Now, it is possible for it to be denied, but again, it's relatively unlikely. The court will issue an interim order, and interim orders are only good for a short amount of time. So usually, if you get it, let's say on a Saturday, they'll make it come back on Tuesday for a temporary order. Now, the temporary order is, again, a short-term order. It's temporary. It'll last for 7 days. So the temporary order can order the abuser not to abuse, threaten to abuse, or harass you. It can order the abuser to stay away from your home. It can vacate the abuser from your home. That means the order can make the abuser leave your home. It can give you temporary custody of any minor children. It can order the abuser to stay away from another location or from someone else if you'd like. There are actually a lot of remedies that are offered to try to keep you safe. The temporary will last for 7 days, and then you'll have a final protective order hearing. The final protective order is usually good for 1 year. At that time, the court can do the same sorts of things. So they can do temporary custody, they can do a vacate, they can order the abuser to stay away from you, to stay away from your home, your workplace, another house if you'd like, and they can order what's called emergency family maintenance. And that is designed to be money that would help to support you because you've had to leave the situation because of domestic violence. It's important that you think about the protective order has lots of remedies, but they have really big implications. So while it's relatively easy to get an interim and a temporary, and again, when I say easy, it's because the burden is relatively low to get those orders, it is much more difficult to get a final protective order. When you come to that point, it's important to have an attorney because at a final protective order hearing, there's a couple of options that will be available at court during a protective order. The abuser could consent to the entry of a protective order against them. That would mean that the court would enter a protective order without any findings of fact. It means that the court wouldn't hear any information and wouldn't make a determination as to whether or not the abuse happened or not. But they could issue the relief. So they could issue a temporary custody order. They could issue vacates and stay away provisions for a protective order. If the abuser won't consent to the entry of a protective order against them, then if you want to seek a protective order, you'll have to have a hearing. At that time, you'll have to have a hearing on whether or not the court should grant you a protective order based on the incident of abuse. The court will hear information from you and from the abuser. The court will allow the abuser to cross-examine you. You'll be able to cross-examine the abuser, but it will be a formal court proceeding. It will be the rules of evidence will be in place, and the court will have to adhere to those rules. It's important to be able to navigate them and to understand what's important and what's not. That's where a lawyer can be essential in making sure that you present the evidence that you need to present and make objections where you need to make objections in order to be successful in your pursuit of the protective order. Now, when someone files a protective order against you, it's equally as important to find representation, because the relief that's offered in a protective order has relatively big stakes. It could, like I said, you could get a vacate, which means the abuser would be removed from their house for up to a year. There's money that's at stake. There's custody of children. All these things are important. And in a hearing, again, evidence rules are important. Objections are important. Forms of questions are all important. Those things are of significant importance for the court. Therefore, it should be something that you take seriously. And when you move forward, you should let a lawyer help you navigate through that process. We have a lot of clients who seek a protective order and they're married to their abuser. Then they have separation issues, divorce issues that we also have to deal with. Those are important steps that need to be addressed as well. If you have children or a child in common with your abuser, then there's custody issues, there's child support issues that may come up. It's important to think about that and think about how to make a plan to address the protective order, the safety concerns, but also what might be coming next in terms of a separation agreement, filing for divorce, and how to proceed down the path. It's important to make a plan, to think about how to approach it step by step. We're happy to help you through it. We can walk you through from the protective order to a separation, to a divorce, to custody concerns, to child support. We're happy to help you with that. We're here to help. Let us be your advocate. Give us a call. Our number is 301-515-1190, or we can be reached at alicelawlaw.com. We're happy to meet in person or by the phone. Whatever works for you, we're happy to help.